Asset protection strategies are legal methods designed to shield your wealth from lawsuits, creditors, and financial judgments. In today's litigious society, anyone with significant assets faces potential threats from unexpected lawsuits, business liabilities, or creditor claims. Whether you're a business owner, professional, or investor, understanding how to legally protect what you've built is essential for long-term financial security. These strategies involve creating legal barriers between your assets and potential claimants, using various structures like trusts, limited liability companies, and insurance policies. The key is proactive planning, establishing these protections before any claims arise, not after. Understanding why asset protection is crucial begins with recognizing the risks. Litigation risk is real. Lawsuits can target your accumulated wealth regardless of whether you're actually at fault. Even frivolous lawsuits can be costly to defend. Creditor claims, whether from business debts or personal obligations, can threaten your financial security and everything you've worked to build. This is why proactive defense is so important. Legal structures must be established well before any claims arise. Courts scrutinize transfers made after a creditor appears, often viewing them as fraudulent. Finally, wealth preservation isn't just about protecting yourself, it's about ensuring your assets remain intact for future generations, creating a lasting legacy for your family. Asset protection trusts are powerful legal tools that separate ownership of assets from the person who benefits from them. Domestic asset protection trusts are irrevocable trusts established in specific United States states like Nevada, Delaware, or South Dakota. These trusts shield assets from creditors while allowing you, the settlor, to maintain some benefits. However, they must comply with strict requirements to be effective. Offshore asset protection trusts, established in foreign jurisdictions like the Cook Islands or Nevis, provide even stronger protection. These jurisdictions don't recognize United States court judgments, making it extremely difficult and expensive for creditors to pursue claims. Finally, Medicaid asset protection trusts are specialized structures designed to protect assets from long-term care costs while preserving eligibility for Medicaid benefits, though they require careful timing due to look-back periods. Limited liability companies, or LLCs, are one of the most popular and accessible asset protection tools available. The primary benefit is limited liability protection. LLCs create a legal separation between your personal assets and business liabilities. If the LLC is sued, generally only the assets held within the LLC are at risk, not your personal savings, home, or other property. Asset segregation is another powerful strategy. Real estate investors often hold each property in a separate LLC, so if one property faces a lawsuit, the other properties remain protected. Charging order protection is a unique feature of LLCs. If a creditor obtains a judgment against you personally, in many states they can only receive a charging order, which entitles them to distributions but doesn't give them control over the LLC or the ability to force liquidation. Finally, LLCs are relatively easy to form and maintain compared to corporations, making them an efficient choice for asset protection. Insurance is often the first line of defense in asset protection. Umbrella liability insurance provides excess coverage that kicks in when your standard homeowners, auto, or other liability policies reach their limits. For example, if you're found liable for a car accident and the damages exceed your auto insurance policy, umbrella coverage protects your personal assets from being seized to satisfy the judgment. Professional liability insurance, also known as errors and omissions insurance, shields professionals like doctors, lawyers, and accountants from malpractice claims. For high-risk professions, this coverage is absolutely critical. The homestead exemption is a state law provision that protects a certain amount of equity in your primary residence from creditors. The amount varies significantly by state. Some states like Florida and Texas offer unlimited protection, while others provide limited or no protection. Life insurance cash value is another often overlooked protected asset. Many states exempt life insurance policies from creditor claims, allowing you to build wealth in a protected vehicle while also providing for your beneficiaries. Retirement accounts offer some of the strongest asset protection available under federal and state law. ERISA qualified plans, which include 401k plans, pension plans, and profit-sharing accounts, receive unlimited federal creditor protection under the Employee Retirement Income Security Act. This means creditors generally cannot touch these assets, even in bankruptcy. Traditional and Roth IRAs also receive protection, though it's more limited. In bankruptcy proceedings, IRAs are protected up to approximately $1.5 million, with this amount adjusted periodically for inflation. Protection from other types of creditors varies by state law. The rollover strategy is important to understand. When you roll over funds from an employer-sponsored plan into an IRA, those funds may maintain their unlimited protection status if properly documented as rollover funds rather than direct contributions. However, there's an important timing consideration. Contributions made to retirement accounts after a creditor claim has arisen may be considered fraudulent transfers and could be reversed by a court, so early and consistent funding is essential. Family limited partnerships, or FLPS, are sophisticated structures often used by wealthy families for both asset protection and estate planning. The ownership structure divides control from ownership. General partners, typically the parents, maintain full control over the partnership's assets and operations. Limited partners, often the children or other family members, own interests in the partnership but have no management rights or control. This structure provides powerful creditor limitations. If a creditor obtains a judgment against a limited partner, they typically can only receive a charging order. This means the creditor is entitled to receive distributions if and when the general partner decides to make them, but the creditor cannot force liquidation, access the partnership's assets directly, or participate in management. Family limited partnerships also provide valuation discounts for estate and gift tax purposes. Because limited partnership interests lack control and marketability, they can be valued at a discount, often 20 to 40%, reducing estate tax exposure when transferring wealth to the next generation. Finally, FLPS facilitate gradual wealth transfer. Parents can gift limited partnership interests to children over time, using annual gift tax exclusions, while maintaining control of the assets as general partners. Timing is absolutely critical in asset protection planning. You must act proactively, implementing strategies well before any claims or lawsuits arise. Courts are highly suspicious of asset transfers made after a creditor appears, and reactive planning is often viewed as an attempt to defraud creditors. The doctrine of fraudulent transfer allows courts to reverse asset transfers made with the intent to hinder, delay, or defraud creditors. If a court determines a transfer was fraudulent, it can be undone, and the assets returned to satisfy creditor claims. In some cases, fraudulent transfers can even result in criminal penalties. Look-back periods vary depending on the type of claim and jurisdiction. Courts may examine transfers made anywhere from 2 to 10 years before a bankruptcy filing or judgment to detect fraudulent conveyance. This is why early planning is so important. The good faith requirement means your asset protection planning must be legitimate wealth preservation, not an attempt to defraud existing or reasonably foreseeable creditors. Planning done when you're solvent and before any claims exist is much more likely to withstand legal scrutiny than planning done in response to a specific threat. Even well-intentioned asset protection plans can fail if certain mistakes are made. Commingling assets is one of the most common errors. Mixing personal and business funds, using business accounts for personal expenses, or failing to maintain separate bank accounts can destroy the liability protection of LLCs and corporations. Courts may pierce the corporate veil, treating the entity as your alter ego and exposing your personal assets to business liabilities. Improper documentation is another critical mistake. Failing to maintain corporate formalities, such as holding annual meetings, keeping minutes, filing required reports, and maintaining proper records, can invalidate your protective structures. Courts look at whether you treated the entity as a separate legal person. Excessive control over trust assets can defeat the protection a trust is meant to provide. If you retain too much control over an asset protection trust, courts may determine the assets are still effectively yours and available to creditors. This is why independent trustees are often recommended. Finally, DIY implementation is risky. Self-drafted operating agreements, trust documents, or partnership agreements often contain fatal flaws or fail to comply with state law requirements. Professional legal guidance from an attorney experienced in asset protection is essential to ensure your structures are properly established and will hold up under legal scrutiny. As we conclude, let's review the essential principles of asset protection. First, act before claims arise. Asset protection planning must be done proactively, when you're solvent and before any creditor threats exist. Attempting to protect assets after a lawsuit has been filed or a debt has been incurred is likely to fail and may even result in legal consequences. Second, layer multiple strategies. The most effective asset protection doesn't rely on a single tool. Instead, use a combination of structures: LLCs for business assets, trusts for family wealth, insurance for liability coverage, and retirement accounts for long-term savings. This layered approach creates multiple barriers between your assets and potential claimants. Finally, seek professional counsel. Asset protection law is complex and varies significantly by jurisdiction. Working with experienced attorneys, tax advisors, and financial planners ensures your strategies are properly implemented, legally compliant, and tailored to your specific situation. Remember, the cost of proper planning is minimal compared to the potential loss of your life's work. Protect what you've built, secure your family's future, and gain peace of mind knowing your wealth is shielded from unexpected threats.
If you like this video, hit that like button and don't forget to subscribe. Visit CodeLucky.com for more such useful content.